Calling a case of the people of the state of Michigan versus Dennis Dale Cross, file 210390FY. Counsel, identify yourselves for the record.
Atia do so on behalf of the people.
Jason Ball on behalf of Nicholas Cross.
All right, today's time and date set for preliminary examination. I need to first arraign your client on an amended complaint. The only change is the date. The charges have not changed. The date is now listed as March 28th, 2021. Mr. Ball, is your client familiar with the charges associated with this case and the maximum penalties?
He is, Judge. He has a copy of the amended complaint sitting in front of him.
All right, so the amended complaint of March 28th, 2021. I know that client's planning on waiving the preliminary examination. Will be more discussion, but as far as the initial arraignment, how does your client plead to these charges?
Not guilty, Your Honor.
All right, not guilty plea will be entered in records of the court on the arraigned amended complaints. It's my understanding that after discussing with the prosecutor and your client that that your client wishes at this time to waive the preliminary examination. Is that correct?
That is correct, Your Honor.
All right, let's do so. Do the people waive their right to a preliminary examination?
Yes, Your Honor.
All right, may I address your client regarding his knowledge of the process?
Yes, Your Honor.
Mr. Cross, your attorney is recommending that you waive the preliminary examination, probably to continue negotiations in circuit court, or maybe trial strategy. I don't know. It's up to the two of you. I just need to know if you understand what a preliminary examination is.
Yes, sir.
And your attorney is recommending you waive the preliminary examination. Are you planning on following his recommendations?
Yes, sir.
All right, I'm going to make the determination that the waiver has been made knowingly, understandingly, and voluntarily. The matter is now bound over to circuit court. Let's do so. The amended complaint was filed. Did we also file an amended information? Let's see the amended warrant. Let me just take a look.
Oh, I thought so. I have a copy of one here. If the court would like.
Do you have one with the new date on it?
Yes.
That's okay. As long as you have, you believe that it's been filed with the court, I do have it here as well with the March 28th. So that we do have the information. Mr. Ball, do you need me to read the charges to your clients, or is he familiar with the charges and the maximum penalties?
No, Your Honor. We've discussed what he's charged with. We've waived the formal reading.
All right. And how do you plead your client in circuit court?
Not guilty, Your Honor.
Not guilty plea will be entered in records of the court. My understanding is that in chambers there was some discussion. This is the date and time set as well for a hearing on a bond violation. Court rules indicate that I could take into consideration after hearing, or I could initially just make a decision regarding your client's bond situation based upon the police report that was submitted to me. I am willing to listen to the arguments placed, and I suspect that Ms. Dusso is prepared to move forward regarding the contact provision. My initial inclination, without hearing any of the evidence except for looking at the police report, is just to increase the bond amount. If I forfeit the bond, which I could do, then if it's a bond through bail's bondsman, then the defendant loses any money that he has associated with it. I have the right to do that, and if he had contact with her in this serious matter, that is something I could do. Or I could make the decision that I'm just going to increase the bond amount and put a tether provision on. That way, if your client has the financial means in order to secure that, he could do those things with the bond having the bond amount going to $200,000 cash surety. And if he does bond out, there'll be no contact still. He would also have to be on a tether so that he has no contact, cannot come in contact or within a mile of her radius of where she's at, whether she's staying or working. Or I can listen to the hearing. I know that there's multiple times wherein you can address the issue of bond. I can tell you that my first blush intention is something needs to be done. If what's in the report is true, and I hear facts to that case. However, I'm more of an auditory learner rather than a reading learner. I learn things here, but when I hear things, sometimes it gives a little bit different flavor to what's happened.
Judge, it's my understanding that Mr. Cross is prepared to waive his right to have a hearing and would ask the court to consider a review of his bond without testimony.
All right.
I would like the opportunity to address
Go ahead.
bond if Your Honor would allow.
Go right ahead. I'll let the prosecutor have her shot after that.
Judge, since Mr. Cross was arrested in this case, he's been, in my opinion, fully compliant with his bond. He has communicated with me regarding court dates. He has appeared for all court dates prior to this one. He is employed full-time and has a very good job. Unfortunately, if the court is inclined to raise the amount of his bond, it is my opinion, based upon my discussions with Mr. Cross, that he won't be in a position to bond out based upon the payment of his previous bond, his attorney fees. He just doesn't have any additional funds available. We're hoping to have further discussions regarding the negotiation of this case. I believe our next step in circuit court will be requesting a Cobb's hearing. We would ask those things to be taken into consideration, Your Honor. Thank you.
Appreciate that. Let's do so.
Your Honor, I think the indication that the court had made regarding sort of raising the bond and putting that tether provision in place are reasonable. And obviously we can't have him having contact with the victim. And I think that at least allows him the potential. I mean, I realize that he is going to have to come up with funds somehow in order to bond out again. But at least it leaves him the option. It seems better than just a straight revocation or or raising it even higher. So I think the court's plan is appropriate.
Thank you. Just pull up a couple of notes that I had with this file. The initial bond was set by Magistrate Ladwig. He was the reviewing magistrate and had set the initial bond, I think, at $100,000 cash for surety. There were some bond provisions put in place for no contact with the victim, which is standard in cases where there's alleged violence, particularly violence of this nature, rising to the level of the underlying charge of assault by intent to do great bodily harm, less than a crime or murder by strangulation. There were two different counts listed and an aggravated domestic violence, which is 1 year misdemeanor. And initially, when the bond was set, Magistrate Ladwig had the facts in front of him in the affidavit to make a determination as to what an appropriate bond would be. The guy initially said I was going to leave that bond in place. Not having heard the facts of the case of the matter, I was trusting the magistrate making a determination that weighed two things: safety of the community and the defendant showing in court. Coral 6106F1 says I can look at the prior criminal history, I can look at the serious nature of the charges, I can take a look at the determination of the defendant's conduct. Here, the defendant has 6 prior convictions dating back to 1992, felony B&E as a juvenile, 1992 and 1994 felony B&E, 1994. Later that same year, another felony B&E of a vehicle. In 1997, domestic violence, it was dismissed under the spouse abuse deferral. In 1998, it was felony controlled substance possession and the retail fraud, 3rd degree in 2000. The defendant here, in this case, was charged with 4 crimes, 2 of them felonies, and his habitual offender 4th. The habitual offender 4th makes the maximum penalty of his crimes up to life in prison, and he would have been told that. He would have been told that that was his risk, potentially what was happening when the bond was set. A high bond was set with the provisions that he would comply or keep his self in compliance with the law. And an incident report, which I do have and did read, there was contact with the victim. And I've not heard the testimony of it, but I'm cognizant of it. So even knowing that his potential life in prison, even knowing that no contact was a part of that, and even knowing the criminal justice system, had this been an initial charge in place without the habitual offender, I could say he probably doesn't really understand the criminal justice system. But when it's his 7th time through the system and not his first time as a felon, he needs to have a healthy dose of respect for court's terms in order to protect the safety of the community. And therefore, I am going to double his bond to $200,000 cash or surety. I understand the risk that if I forfeited his bond, which I could do, that he would completely be out. I'm not going to do that and allow a provision. Perhaps he has some people willing to help him and able to get out. But if he does raise the additional $100,000 cash or surety, whatever the component is, because I also know he doesn't put up $100,000. He puts up a percentage of that, which I'm certain is steep. He will also need to be on tether. If I read a little more carefully into the affidavit or heard the preliminary examination, because quite frankly, the handwriting is not so great, so it's tough for me to make out the affidavit, I might have decided to revoke the bond. But today I'm just going to do the $200,000 cash or surety and tether if he does make the bond, which he probably could get through a bondsman, as many of them have their tethers now as part of their service. Anything else we need to place on the record to preserve the record? Yes.
What are the terms of the tether?
In terms of the bond, in addition to the $200,000, no contact with the victim, engage pretrial services if he does get out, have a biopsychosocial assessment done, no contact with the victim, no threatening, intimidating, violent, aggressive, abusive, disorderly behavior towards any person or any of that behavior, not to consume alcoholic beverages, illegal drugs, not to consume recreational marijuana, random drug and alcohol testing, because I'm looking at his prior criminal history includes some of that in the history of it. And he is to be on the tether, not to be within 1 mile radius of the victim, whether at home or at work, wherever she's at. Obviously, small town, is there an inadvertent, that would be left to the judge's discretion. It's tough to stay 1 mile away in a small community like this, but he knows where she works and he knows where she lives. He's to stay 1 mile radius. Does that answer the question?
Yes, Your Honor, I appreciate it.
All right, let's do so. Is there anything else you need to place on the record to preserve the record for the people?
No, Your Honor.
Anything, Mr. Ball, to put on the record to preserve the record for the defense?
No, Your Honor.
All right, we'll be adjourned on this case at this time. He's remanded to